Hey guys, it's our Shawn. We are going to be talking tonight about what do we do to exit a business when the partner doesn't want to. When your partner doesn't want to exit, but you want to get out. This is a common situation that many business owners find themselves at some point in the course of the business. Maybe you don't like your partner. Maybe the market shifted. Maybe you've got new priorities. Whatever the case might be, you might want to exit the business at a time your partner doesn't want to. So tonight we're going to talk about some general ideas, tips, tricks, things you can use in this situation. Now, I have to qualify this by saying this is talking generally, right? So we're talking broadly about what's possible. It's not specific legal advice for you or your situation. We're also not going to go deep on state law. Corporate law is somewhat similar from state to state, but different statutes, different case law, different options. So you're really going to have to dive deeper in your state, in your situation with your counsel. It'll become clear why here in a minute. You're going to have to go deeper with somebody who has an expertise. So this isn't specific legal advice. It does give you an idea of what to look at if you're ever in this situation. Or you know somebody is, you just want to know what happens in these types of situations. I'm going to give you the blanket overview so that you can then dive into it. So just start by knowing it is a tricky situation. It's never a great situation when you have business partners in a business and they can't agree on where to go next. So you're going to probably have to work through things with that partner. We'll talk about that in a few minutes. So if the relationship's not good, it's tough. It's maybe one of those situations where you need to, suck it up and figure out how to get along with your partner, or you may have to bring in lawyers and third parties, which can get very expensive. So it's never a good situation when you get into one of these ending a partnership relationship positions, and you may have to do some additional work to make it happen. It may get very expensive, which is why in a perfect world, you're going to build provisions in looking to the possibility of this when you start the partnership. You'd rather be ahead of the issue than behind it. And the time to get ahead of the issue is when you're setting up the partnership. You want to anticipate this. So bonus points to those of you that are watching this in anticipation of what the future might hold or getting ready for your next partnership. That's the time to talk about these things. So the key documents and provisions is going to be the business law in your jurisdiction, generally where the partnership was incorporated or formed, what state you picked as your formation state. And then you're also going to be looking at your agreements, whether that's your LLC agreement, your corporate documents, your shareholder agreements, whatever you put together when this thing was put together. And a lot of people use internet forms or other documents. So you're going to have to go dig through the hard drive, dig through the emails, maybe dig out some documents, whatever you guys and gals sign when you form the partnership, that's going to control along with the state law. And a lot of times the state law has different ways of dealing with what we often call a deadlock situation or a minority partner or whatever the case might be. You're going to have to also look at that. And whether you're an LLC or a corporation or a partnership, all becomes very relevant here. Because that corporate statute may be different, may have different rights and remedies than other corporate statute. So you got to really do that detailed analysis. A good lawyer should be familiar with the statutes, should be able to go through there, should run through the agreements, understand what a lot of those key provisions are. So it's really a time to get a good experienced person on your team and say, let's take a look through this. Let's understand what our options are. So if we can't get an agreement with our partner, we got to fall back to the agreements. The agreements are going to control. And if the agreements are silent, then the next fallback is that state law. And usually there's some type of provision to end it. Although it may be expensive, it may involve a court hearing. It may be difficult to do. There are often provisions in the corporate law that say if people are hopelessly deadlocked, then you can bring the judge in and the judge will decide. But it may cost a fortune to get there. So again, you're hoping there's a provision in the agreement. If there's not a provision in the agreement, you probably want to kick out to your partner and say, hey, can we work this out and see if you can't get cooler heads together. Unfortunately, what often happens here is once wind gets out that there's a disagreement, people stop talking. And rather than being logical and saying, hey, let's divide the money up, keep our costs down, People start communicating through their lawyers and their counsel and third parties, and it becomes very, very expensive. So we got to agree. We got to read those agreements carefully. What are our options if there's not an agreement? If we've read the agreement, we've looked at all the provisions, we've talked to a smart lawyer who's looked at those provisions with us and made sure there's no way to wiggle and use one of those provisions to get into a sale or to break the deadlock with our partner, and we want out, then we've got to go and figure out what our options are. Number one, could you sell the stock? Could you sell the interest? Oftentimes in the agreement, there's provisions in there saying you can't sell to third parties, you can't liquidate it. But depending on who drafted it, who put it together, there may not be such a provision. So there is a possibility you could sell to a third party. Third party would be more interested if it was a controlling provision or position rather than not. But you're going to have to go talk to them and see if that's possible. Can your agreement allow it? Can you find a buyer? Could you sell? Some other interesting options bridge off of that. Obviously, if you have a controlling position, corporation law, you might be able to do some kind of squeeze out merger. And we won't get into that in detail, but know that there's an option to potentially merge your company into another company. And through that process, eliminate stockholders, which would get you down to one stockholder. You'd have to pay fair value. There would be a lot of potential litigation in a squeeze out merger, at least done under Delaware law. So possibility for a Delaware corporation is to do a squeeze out if you have the majority position. The better option probably is to work a deal out with your partner. Somehow figure out a way to sit down at the table and get to logic. It may be your lawyer talking to their lawyer, but at some point you got to get the logic of cooler heads have to prevail. Let's just talk numbers. Let's be business people and bring our different interests together and figure out how to do it. And then kind of your last option, if your agreement's silent, your corporate law doesn't help you, you can't get your partner to the table, the last thing you want to do is litigation. And this is usually something you want to avoid because once you open the door of litigation, you're going to have the back and forth. It usually gets ugly. It inevitably is expensive. You start with what they call discovery, which means everybody's producing papers to the other side. Everybody's getting familiar with all the details. All those agreements and documents and emails that we were talking about earlier that should be the foundation of your partnership, business agreement, whatever form it is, whether it's corporation, LLC, partnership, all those documents are coming back out on the table, right? And now the lawyers are reading them and they're looking through them with a fine-tooth comb and they're looking for arguments. Depending on the size and complexity of litigation, you may have to have hearings about procedural motions. You may have hearings about whether things are admissible or not admissible. You may have to have pre-trial hearings or mediations with your judges. And what you should be thinking here is ching, ching, ching. Money is flying out the window. Sometimes you spend more on litigation than what the business is worth. I've seen that happen, unfortunately. You're in the litigation, you're stuck, can't really get out if you're the one being sued unless you reach a settlement. So you're along for the ride. And then the discovery request comes. You might have to have meetings with the judge. You may have to fly and stay in another city, get a hotel room, certainly lawyers for these hearings, lawyers to prep for the hearings. You're starting to look at a lot of expense. So that's why if you can get cooler heads to prevail, what you really want to do when you're in a disagreement with your partner is to end amicably, walk away, divide the money, shake hands, and just go your separate ways and move on with the business and figure out a way that can happen. That is your best case scenario almost always. The prospect of litigation is too expensive. Probably worth bringing a lawyer in to negotiate and try to work it out. Definitely you want somebody to look over your documents and understand them completely. You probably don't want to go that alone unless you have a lot of expertise in the area, because that corporate law or business law and the documents are going to interface with each other. You got to really understand what outcomes you have. You don't want to be guessing. So you really want to get there. And then the last case is litigation. And unfortunately, if your agreements are silent, your corporate law doesn't help you out, there's nowhere else to go, and you can't get an agreement with your partner, you're going to end up in litigation, and it's probably going to get expensive. And that's bad news for everybody. So that's what we like to avoid. That's what we like to keep away from. Love to hear your questions. Drop them in a comment. We answer a lot of questions from listeners and viewers. Obviously, we can't do answers for specific legal cases because this is not, obviously, this is not attorney-client privilege. It's not confidential when we just post it on the internet. If you have general questions, a what if kind of idea question generally about business, we love to talk about it here on the McBride Attorneys Law Show. Hope you're subscribed to our YouTube channel by the same name, McBride Attorneys Law Show. Ring the bell for notifications. Go out there, check out. There's a ton of past episodes there, things you can get yourself familiar with. We'll have more coming as we hear from you. So I'm looking forward to reading your comments. Tell your friends, make sure they're subscribed, and come hang out.